from the College by the Lake, Coeur d'Alene, Idaho. Local, regional, national, and international guests discussing the issues and topics affecting the way you live are on Forum, the North Idaho College Public Forum, with your host and moderator, political scientist Tony Stewart.
I am most pleased to welcome you to a 6-week series that is entitled The People's Law School. We could subtitle that Know the Law, and during that 6 weeks we're going to look at 6 particular areas, one each week, trying to give you information that is going to be provided by attorneys, and on one program we'll have a judge. We're very delighted to be able to help you with some concepts that you might face on legal matters. I must start this program and this series by indicating that we want to thank very much the Conflict Resolution Center of the Inland Northwest Incorporated. They put this program together, not only this TV series, but also a 9-week program at North Idaho College that is also entitled The People's Law School. We would also like to thank the Community Education Department at North Idaho College, the First District Bar Association of Idaho, and the Kootenai County Bar Group, as well as the Spokesman Review and the Coeur d'Alene Press. All of those have been a part of putting this very helpful series together. On the first program, we're going to address family law, and we're very pleased to have 2 attorneys who are an expert in this area that will just answer our questions over the next 30 minutes. First of all, welcome to the program Rob Robinson, whose law offices are in Coeur d'Alene, Idaho. And next to him is attorney Sue Flammey with her offices in this city. And I should add that she is also the president of the Conflict Resolution Center of the Inland Northwest Board of Directors. Welcome to both of you. And
thank you.
We're pleased to have you here, and thank you for the series, Sue. Also, I'm very pleased to have our regular panel. First of all is Janelle Burke, who is an attorney in the state of Idaho. And next to her is Steve Shink, who is the Dean of College Relations and Development at North Idaho College. And I shall ask Janelle to commence today's series of questions.
My first question will be for you, Mr. Robinson, and can you tell us what is exactly a divorce action? What does it mean? What does it encompass?
Divorce action entails a process by which we are seeking to dissolve a marriage relationship, if you will. And so you start a legal action with respect to divorce by the filing of a summons and complaint. The papers are served upon the defendant's spouse, and the defendant's spouse has the opportunity to file a response using the form of an answer. The purpose of the dissolution action is to not only separate the 2 parties in terms of their relationship, but also to make provisions for the award of custody, the award of visitation, the determination of who should be providing health care for the children, child support, life insurance possibly for the children, and making provisions in some cases for ongoing spousal support for the spouse if the spouse, she or he, is disadvantaged in some way and the other party has the ability to do so. The divorce action also seeks to divide the parties' property. In this state we're talking about community property, and as well as community debts. And last but not least, usually there's some provision for either the award of attorney's fees or no attorney's fees, but that's normally at the conclusion of the divorce decree. So that's it basically in a nutshell.
And Sue, with regard to grounds for divorce, what are the grounds for divorce? And I'm talking about not just in Idaho, but across the board, what have been traditional grounds for divorce and what is the trend today?
Thank you, Janelle. The grounds that exist include adultery, abandonment, insanity is a ground for a divorce. But the trend in the last 20 to 25 years has been to no fault, so that neither party is trying to prove how bad the other party has been. And we find that almost everybody files on the grounds of no fault, which is called irreconcilable differences. It gives more dignity to the parties and a more peaceful end to the marriage.
Steve Sheen.
Rob, as that shift that Sue just described has taken place, has it shifted attention onto the property settlement portion of the divorce proceedings? Is that where the conflict now is likely to occur, or do you see a lot of cases where one or the other of a couple are contesting the divorce action itself?
Well, normally a contest of a divorce action, when you talk about divorce, the initial thing is whether or not they are or not going to get divorced. Mm-hmm. And so there may be a contest there to the extent that one party does not seek a separation of the marriage. And in our state, we have the opportunity to request the court to require some form of reconciliation proceedings, so seek a counseling, explore whether or not the marriage can be retained. But as far as fault goes, fault traditionally has been a allegation that is made by one party or the other seeking some form of support, ongoing support, separate maintenance, if you will. It also can have an effect upon the area that you were talking about, and that is with respect to property settlement. If the parties, one party or the other is seeking a table tip, as I call it, or an unequal division of the party's community property, fault is sometimes considered by the court in making those decisions.
Sue, do I understand this correctly? The divorce decree, the property settlement, and custody, are those three separate legal decisions? Or do they generally handled all at the same time?
Okay. Those are the areas, including also debt, payment of debt, and payment of support. Those are the areas that the court has authority in a divorce action to make a decision for the parties. So those are the children, the property, support of the children, support of the spouse, and the payment of the debts. So those are the topics within the overall divorce action. That's what the court has a power to do. I wanted to go back one second. When we were talking about where fault plays into division, also I want to mention it may not be a ground. The party may file for irreconcilable differences, but violence, whether or not in the presence of a child, is a factor the court must consider in determining where the children should be.
Tony, if I could follow up with one more item. Of those three parts we talked about, divorce, property settlement, custody, the divorce decree it has to be a legal action. A judge has to act on that. Is that correct? Correct. The other two, can they be settled by mediation just between the two parties with no legal document involved? In other words, there would be a legal document of some kind, perhaps a contract that was worked out by the two parties and their attorneys, or does the judge have to take action on those as well? Is that question clear?
Well, generally speaking, I'll respond to that. Generally speaking, all of those issues are going to be resolved and incorporated into the final decree of divorce. But in some instances, you will have the parties work out some of those issues through settlement conferences or mediation, and they will reduce it to a writing in the form of a property settlement agreement. And then they may or may not incorporate that into the decree of divorce. So to answer your question in a roundabout fashion, yes, parties do sometimes resolve issues outside of the divorce action, but I would say in most instances the divorce action and the final decree will incorporate all those issues.
Sue Flammey, this is a really good time to cross that connection with another concept. People travel from state to state, and if they have a divorce, they may be married in one state and a divorce in another one. And it's very confusing for the layperson to talk about some states are what we call community property states and others are not. Would you first of all distinguish between a state that has community property laws and those that don't? And then we're going to have a little more specifics about a community property state.
Thank you, Tony. There are a certain number of states, and I think there are 9 at this time, that have what we call community property as the basis for the acquisition and distribution of property acquired during a marriage. The other states have what's called equitable distribution. They're not community property states per se, and that is a tradition from the Spanish law that went through Mexico and up through California and up into the Northwest, so that all assets acquired during marriage from earnings acquired during marriage are that's all community property, and that means each spouse has an undivided 1/2 interest in all of that property. Anything you received as a gift or from an inheritance is separate property, and the other spouse has no legal interest in that separate property.
Like a gift or inheritance.
Gift or inheritance. But everything else acquired during the marriage from the earnings of either or both spouses is community property. It's a recognition that a marriage is a partnership, and I think it's such a good way to do things.
On the same note, a couple's been married 10 years, and not only have they had earnings, but one or both of them, and sometimes just one of them, has acquired a number of debts. Are they both liable for those debts? In a community property state?
In a community property state, all of the debts that are incurred during marriage, if they aren't affecting separate property, are community property. So if I go out and buy a car, my husband's liable for half of that debt. If I go out and get a signature loan at the bank, my husband's automatically liable for one half of that.
Even if the title of the car is only in one name, they're both liable?
They're both liable, yes.
Okay. Another point on this line, suppose someone's through an inheritance, 2 years into the marriage is inherited $150,000. Then they stay married another 6 or 8 years, and that particular money has been drawing interest and so forth. Is the interest exempt from the spouse, or does that become part of the earnings and income?
Rents, issues, and profits of separate property are community property. So the interest is community asset, and each party would have the right to one half of that.
Now Rob, would you take it? Go ahead.
Yeah, I might just interject. I think that Sue is speaking from the standpoint of the state of Idaho.
Yeah.
Now, other states have a little bit of a different perspective. I think in California, if I remember way back when I was down there, I believe that they would treat that differently. They would say rents, issues, and profits off separate property retains the underlying character of the source, which would be separate property, thus retains separate property.
So even community property states are not identical in how they define community property.
It gets very technical and very. That's where the fine points of the law come in when you're talking about separate and community, and also the commingling. You can have a gift that you receive, you put it in the bank, assuming a cash gift, you put it in the bank, you keep it in your own name, that's fine, it will remain separate. But if you put that money into your joint account and you put other community money into that account, that money is commingled, and most likely it would be considered a community asset. So there are many complications in that area, separate and community. But overall, community property is that acquired during the marriage.
Suppose that a couple's getting divorced and they have property in 3 states, and they're in state A, which has the kind of community property you're describing. But as they settle the property in other states, are they required to follow the laws of the state where that property is, or can they have that all combined in the court decree in the state where they're getting a divorce? Rob, would you?
Okay.
Well, I think that's part of the meandering that's done, lobbying, if you will, as to the parties deciding where they're going to file and where they're going to get it adjudicated. And I suppose that you may see parties file in 2 different jurisdictions, but generally speaking, the one that is the primary jurisdiction is going to be one that's going to determine, and they may have to apply the choice of law of the other state. I can't say that I've had any specific experience in that regard, but I remember a case that Sue and I had, and we were lobbying back and forth between whether the case would be heard here or in the state of Oregon, and there was reasons for that. It's exactly what you're talking about.
I have one more question back to the panel. Let's talk about the states, Sue, that you've identified. A lot of states that don't have what we call the general community property laws, and I believe Rob made this reference to this too. Describe how that is different from community property states on divorce. Or who wants to take that question?
Well, as I understand, I'm licensed in Idaho, right?
Right.
But as I understand, when you acquire property, that is in your name and it is considered your property. So if the husband acquires property, it's his. If the wife acquires property during marriage, it's hers. So at the time of divorce, they have a list of all of the assets that were acquired, and then they do a fair division.
So I hear you saying that if you're in a community property state and you're very concerned about certain property not being mingled or be half and half, that it would be more important to have some kind of premarital agreement in a community property state. Would that be a safe assumption?
Well, it's a good idea depending on the circumstances. And as more and more individuals are marrying a second time, many of them want to preserve the assets they acquired before the second marriage so that they have those assets for their families at the time of their death. So they make a premarital agreement which says the property I own now at the time of this marriage will remain my separate property.
And you can do that in a community property state or the other type, either one.
Well, you can do that in a community property state. The thing that's really important about that is that there be full disclosure. The Idaho court is upholding these agreements, and I understand that these agreements are being upheld in other community property states. The main thing, though, is full disclosure. Both sides have lawyers representing them. And if you want to affect the rights of creditors, you must have a memorandum of agreement recorded so that the creditors are on notice that there is a premarital agreement.
Okay. Janelle Burke.
Well, we've talked a little bit about community property, but we haven't really said what separate property is. That is the property that came to a person before the marriage, which may retain its character, as I understand it, and also that property that's acquired during the marriage by gift or by inheritance. There are certain items that are probably going to be the major assets in most marriages. For example, the house may be, or the real property. And then there may also be the question of retirement benefits. And so my question is, let's start with Sue this time, with regard to retirement benefits. Is that a division that has to occur at the time of the divorce?
Yes, and the retirement funds are one of the main assets of most marital estates. And yes, almost all pensions are capable of being divided at the time of the divorce. And each spouse has a 1/2 interest in that pension. And the reason I say most of them, there are some federal pensions that are not subject to state law. And that would be, anyone facing these issues should have the advice of a competent lawyer. But almost all other pensions are divisible in the divorce.
And those are called what? Quadros, is that correct?
Oh, and there is a special order. This is a federal law that permits the creation of a domestic relations order so that the pension plan administrator can divide those funds before the employee is able to reach retirement age. So that can all be done so that we're protecting the non-employee spouse to be sure that spouse has a share in that pension.
Rob, I wanted to ask you about alimony. The old concept of alimony, what's happened to it?
Well, it's changed somewhat, going back to the question that was presented to me earlier about fault. Fault was one of the linchpin, if you will, the beginning of the spousal support statute, and it has been removed from the initial threshold of the statute and put down as the very last factor that the court is to consider. So spousal support now is not a factor. The person who is requesting it does not have to prove fault at the outset in order to then go to the next inquiry. The primary thing that the court's looking at is whether or not the person that's requesting spousal support has the assets or resources to support herself or himself independent of the other spouse, or has the physical and mental ability to go out and acquire employment or is employed or not. If the answer to either of those questions is in the affirmative, then in most instances spousal support will be will be declined. I mean, they won't allow it to be awarded.
Steve Sheen.
Sue, and I know that your primary job is not as a marriage counselor, but you hate to plan for failure, and yet actuarially, I guess the statistics say that better than half of marriages end in divorce in this country, and I'm not sure about Canada. What ought people to do when they're considering getting married? And I certainly didn't think about this. Thankfully, I haven't had to. But if you were going to give somebody some advice, we hear about prenuptial agreements. Are they important, or are there other things that they should think about and talk about before they decide to get married?
Steve, I think it depends on their status. If we have two young people marrying for the first time and they're essentially equal in their economic situations, then probably a premarital agreement prenuptial agreement isn't necessary. It comes into play when one party has a lot of assets and the other one does not, or if, as I mentioned, a second marriage and both parties bring assets, whether a lot of assets or not a lot of assets. If they're both bringing assets to that second marriage, they want to keep them separate so that they have them for the families in the future. So in terms of a young couple coming to me, do I need a premarital agreement? I would say, here's what it can do. What is your situation? If you don't need it, then don't do it. On the other hand, I always tell my clients, if they have gone through a divorce, I say, if you should remarry, be sure you have a premarital agreement. Always. And some of them do, and most of them don't.
And Rob, my question for you is sort of the flip side of the one I just asked Sue. Unfortunately, it seems that oftentimes when marriage ends in divorce, it's not a pleasant thing. What should a person do, either husband or wife, when it's obvious that one or the other is going to file for divorce? What can they do to protect themselves at that point?
Well, I think obviously the first recommendation I would give to them would be to see a lawyer. That can be somewhat costly at times, but for initial consult, shouldn't be too expensive. By going to see a lawyer, they can get advice as to all the factors that we've talked about here today, whether spousal support applies, the Idaho Child Support Guidelines, or whatever, Washington guidelines, California guidelines. There are guidelines that have been pumped out and are now been adopted by the various Supreme Courts to give litigants an idea as to what the amount of child support that should be awarded, how custody, what the laws in that particular state are regarding custody and visitation, the community property or equal property laws, if you will, that exist, and both with respect to the property as well as the debts. Those things people should be obtaining advice on, particularly if they have significant assets or if they have children or if they have businesses or if they have a retirement. Those kind of things, I would suggest that they see a lawyer and get some advice on that.
Quick follow-up question, if I can. You hear horror stories about people who, one party angry over the divorce, run out and run up huge bills. Are you trapped in that community property situation? Or is there some way that you can say, hey, I filed for divorce, I'm not going to be responsible for your debts during this period while we're seeking a final legal remedy? Or nothing at all that can be done?
You know, Steve, I think that as more of us, Rob and I, for example, are mediators, what we would recommend to people is, you've loved one another. If you no longer can live together, do this in a civilized way, which means sit down with the mediator, who is a neutral person, look over the cash flow, look over the costs for running two houses, look over all of the list of assets, and most particularly look after your children. And here are some of the things you can do. And do it in a civilized way, because yes, all of those debts that are incurred are going to have to be paid, and it's a substantial problem in so many divorces. And the court will put an injunction to say no more debt, no hiding assets, no destruction of assets, and so on. But if that happens after the debt's already incurred, the debt does have to be paid. So
we're really running short on time. We must not end the program without talking about the children. And there's something called joint custody of children, and also something determined that one parent gets the total custody of the children. Rob, we'll start with you on this. What are some of the guidelines? I know there's been some changes over time with both spouses often working. What are some of the rules and procedures that the court uses in determining child custody and support?
In the state of Idaho, Tony, ever since 1983, our state legislature adopted a statute that requires, or mandates, if you will, the court to consider joint custody. And with respect to that, the court needs to make some kind of award in that regard. If it does not, then it has to make specific findings of fact and conclusions of law as to why joint custody is not in the best interest of the minor child.
So going into the case, unless there's some other circumstance, the court really likes to give joint custody to both parents. Is that correct?
Well, I think that's the philosophy that has been handed down by our state legislature, and I think that the people in the state of Idaho have been very supportive of that. I think, I guess it's been my experience that joint custody is something you see in almost all divorce cases where children are involved. Very seldom do you see a sole custody situation. That's
Give us an
usually-
example where you would, though.
Well, the obvious example is where the defendant spouse, the responsive spouse, doesn't respond. It goes by default. So the plaintiff asks for sole custody, defendant doesn't respond. That's where you see it the most. Now, if it was a contested case, you probably, even then, you would probably still see some form of joint custody, probably joint legal custody. It's usually in abdication cases where you might see sole custody. But if the two parties are out there, they're raising their hands, say, we're interested in our children, then you're going to see usually joint legal and some form of joint physical custody. Now, they may have one party vested with primary physical custody and the other party having reasonable and liberal visitation rights to include whatever. And that's what Sue and I spent a lot of time when we were called upon as mediators, is dealing with the whatever, trying to work with the parties to carve out something, a parenting plan, if you will, that will fit their respective schedules.
But I would go to Sue and say, though, you're also very concerned about domestic violence, which is next week's program, but there could be cases where there's been criminal prosecution or where a parent could lose total custody because of the violence directed at the children. I mean, there are other reasons why you could have sole custody to one parent.
Yes, Tony, there are. And we're very concerned about all of the fighting that's going on after divorce. And one of the reasons for mediation as a process, and it is mandated through a Supreme Court rule, is to provide parents an opportunity to peacefully resolve how to co-parent after that divorce is over. We know the research shows that children are healthier if they are able to have peace and have a good relationship with both mom and dad after the divorce.
The court can also appoint a guardian for the children to protect them in this fighting process, too.
Yes,
okay.
And I think we'll see more of that.
I'm so sorry to have to say we're out of time. On behalf of our panel and our staff, I would like to thank Sue Flamia and Rob Robertson for an incredibly informative program. And again, I thank you for putting together not only these TV programs, but the course at North Idaho College. And ladies and gentlemen, I would invite you to be with us next week when we'll start program number 2 of this 6-week series on what we describe as the People's Law School. And I'm happy to report that each of those programs will have experts. And next week's topic will be domestic violence, which is a very serious problem in our country. And we're going to talk about some statistics in relation to the extent of that problem and some of the legal remedies that are available, and also some conflict resolution procedures. Until next week, I wish you a very good week. I am Tony Stewart.
The North Idaho College Public Forum was videotaped live from the studios of Instructional Technology on the campus of North Idaho College for viewing at this more appropriate time. We invite you to join us again next week for another all-new edition of the North Idaho College Public Forum on this public television station.